Welcome to Landmark Chambers webinar, Bridging the Gap, Property Pointers for Planners. This follows our webinar from last month on planning pointers for property practitioners. We're really delighted to see so many of you interested in joining the session today and hope that you will find the presentations and discussion to be useful and informative. My name is Jenny Wigley QC and I will chair the session today, joined by my colleagues Miriam Stacey QC, Miriam Seitler and Kimberley Ziya, whom I will formally introduce in a moment. To begin with though, we just have a few housekeeping points, which I'm sure you're all becoming pretty familiar with. Your microphones are automatically muted, so you will not need to adjust your local settings. We very much welcome questions throughout the session and please submit them via the text in the Q&A section, which will be found at the top or bottom of your screen. We have actually got quite a lot to get through today, so time permitting, we will try to answer some questions at the end, but in any case, they won't be lost. We'll feed them into a future webinar in this series. Towards the end of the discussion, we will ask you to assist by answering some Zoom polls, and the results will be anonymous, but some of them will be used to direct the discussion and decide the content of future webinars. The webinar will be recorded and you'll receive a link to the presentation and the recording shortly after the event concludes. And if your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. So I'll begin then by introducing today's speakers. We have Myriam Stacey QC, who's a silk in our property group, and she deals with all aspects of property litigation. She has considerable experience in acting in cases about developments, and her clients range from individual householders to local authorities and large commercial developers and landowners. Miriam Seitler is a junior barrister in the property group and has significant experience in both commercial and residential property work, but she acts in all aspects of property. And then we have Kim, who joined Chambers in 2019, and she's building a practice in all three of Landmark's main areas, but with a particular focus on both property and planning and the crossover between the two. She frequently advises on a range of property issues, including the topics we're covering today, but today she's kindly agreed again to wear her planning rather than property hat. So I'll just briefly explain the structure of what we'll be doing today. First, we'll be doing some quick fire and perhaps not so quick fire, but some quick fire questions, which we hope are questions you've always wanted to ask a property practitioner. And we're focusing on two particular subjects today, restrictive covenants and easements, things like rights of way and rights of light. And then we'll move on to some more detailed scenarios, types of things that we've come across in practice. And we'll be discussing the points to consider in those scenarios. And we'll be also asking you to give your views by some Zoom polls at that stage. And then we'll conclude if we have time, with some questions. So we'll move on then straight away to the quick fire questions. And I'm going to start on the restrictive covenant topic with perhaps the most fundamental point to Miriam. This is Myriam Stacey. Miriam, just remind us what actually is a restrictive covenant and what kind of restrictions can be imposed?
So Jenny, a restrictive covenant, as the name somewhat suggests, it's a binding promise by one landowner to another, usually contained in a conveyance or a deed, to accept a restriction on what the property can be used for. And it's with a view generally to preserving the amenity, the value and the enjoyment of the adjoining land of the covenantee, so the person with whom the covenant's made. And it often arises where a big plot of land is subdivided. So developers will often find that where there's been a parcelling off of an old estate, often many, many years ago, sometimes 100 years ago or more, restrictions were imposed on the parcels which prevent or can impede development. So far as what kinds of restrictions can come up, well, they range from the very specific to the very general. On the general side of things, you can have covenants, for example, not to build at all, or not to build other than what's there, not to alter the existing buildings. And in terms of more specific, there can be covenants limiting the number of buildings to perhaps one dwelling, or the types of buildings. There can be prohibitions on certain trades or businesses, so the type of use. We've come across covenants not to build beyond a certain building line, and restrictions on height, for example, right down to controlling window frames and the paint colour. So as I say, there's a range. That's what a restrictive covenant is.
Great, thanks. So Kim, I think you had a question.
Yeah, so Miriam, how can I find out if a particular piece of land is burdened by one of these restrictive covenants?
So firstly, you need to establish whether you're dealing with registered land or unregistered land. If you're dealing with registered land, then land registry is the starting point. So you're looking at the official office copy entries. Specifically, if you're looking at whether there's a restrictive covenant burdening your land, you need to look at the office copy entries of the potentially burdened land. If the land's unregistered, then you need to be looking at the land charges register. This is something that conveyancer will often do and report on purchase of the property. But if that hasn't been done, then it's certainly something that you should be taking advice on before you kind of take any steps with any development. Just to be clear, there might not be express reference to the particular covenant, so it might not say on the office copy entry, this property cannot be used for anything other than a private dwelling house. It might just say something much more generic, like there are restrictive covenants contained in a conveyance dated this, in which case you might need to do a bit more further digging, or those advising you might have to. But that's certainly the starting point. If there's any ambiguity or you need to resolve a conflict or uncertainty about whether a covenant is enforceable or not, then there is a specific provision under the Law of Property Act 1925, whereby anyone interested can apply for a court declaration as to whether the covenant is enforceable or not. So that's a route other than just a normal CPR court declaration, where you can get clarity as to the enforceability of a covenant.
Right, I've got another one for you, Miriam, Stacey. Who is subject to the restrictive covenant? So if you've had nothing to do with agreeing to a restrictive covenant, are you still subject to it? Who's burdened by it?
Yeah, so obviously, as you alluded to, the original covenanter, the person who made the promise, is bound through privity of contract. But the trick, I suppose, or the magic of a restrictive covenant, in contrast with a positive covenant, which is a covenant that requires you to do something as opposed to not do something, is that negative covenants, restrictive covenants, can bind successors in title, so can run with the land, as it's called, and bind successors to the original promisor, even though they did not themselves make the promise. In order for that to happen, for the burden to run, there needs to be a number of conditions that need to be satisfied. So firstly, the covenant in question must be restrictive of use. So for example, if the covenant said, do not sell the land for less than a certain price, or I promise not to sue the adjoining owner, that wouldn't qualify because that's not restrictive of use. Secondly, there must be sufficient registration. So the person coming along having purchased the land must be bound, must be taken to have had notice, and that's either against the land registry if it's registered, or as a land charge, as Miriam referred to. And then finally, the language of the covenant itself must suggest that there was an intention for the land to be burdened. And what that means is that the language must demonstrate that there is an intention that the covenant is for the benefit of specific land retained by the person with whom the covenant's made. And that's the first part. And the second part is it must be clear that the covenant wasn't intended to be personal. And those two things are basically determined by looking at the language of the grant in its particular context. So all of those have the potential of raising a dispute in their own right. But if the short answer to your question is successors in title can be bound.
But not by something like a duty to maintain or anything like that, because that would be positive.
That would be positive, exactly.
Okay, right, thank you.
So now, if we know who is bound by the covenant, who can actually go about enforcing it? Miriam, Seitler.
So this is a slightly more complex question than whether the burden has run. You always need to ask whether the benefit has run. So again, the original covenantee will often retain the benefit, in which case there's no difficulty. But if the land has changed hands many times, which is often the case, then you need to make an assessment of whether the benefit has run. So whether the successor in title or any range of successors entitled to different parts of the land can enforce the covenant. And again, here there's a list of various conditions that would need to be satisfied. I think the headline point here is that it's certainly something to take advice on. It's not something to be assumed that the benefit has run. Certainly, even if the burden has run, it's not to be assumed that the covenant can be enforced. So take advice, but in the meantime, there's 4 conditions to be satisfied generally. Firstly, the covenant in the first place needs to have been taken for the advantage of some land which can be identified with reasonable certainty. So it needs to have been clear in the original deed what was to be the benefited land. There's a lot of case law on how clear that and how certain the identification has to be. Secondly, the benefited land has to derive a benefit from the performance of the covenant. So this is often referred to as the touch and concern criteria. And it's really an assessment of whether a breach would affect the value or amenity of the potentially benefited land. Again, the covenant needs to not be purely personal, and as Miriam said, that's an assessment of an interpretation of the covenant in the context of its original deed. And then finally, the benefit needs to have passed either by annexation, assignment, or a building scheme. So since 1925, annexation being the most common method. There's quite a lot more law to go into on that, which I'm not going to touch upon. But those are the headline requirements for the benefit passing.
And
in terms of,
sorry, I might have just cut you in there. Just assuming that you do have the benefit, what are you do? How would you go about enforcing the covenant? What are your available remedies?
So if you've established that the burden has run, or the original covenantor still holds the land, and the benefit has run, then there is a breach of covenant. So that's quite a lot of stages you would have to have surpassed. Then you would have a claim either in the county court or in the High Court to enforce the breach. That would be a claim seeking either an injunction or damages, potentially an interim injunction, depending on what stage you are at in terms of the development.
I think that's stolen my, perhaps Miriam's thunder in answer to my next question a little bit, but perhaps Miriam could just elaborate on that a little bit more. So what are the consequences of being in breach? What can the...
Yeah, well, there's a lot. There's no thunder stolen at all, because that was a good intro. In terms of the remedy, a restrictive covenant will obviously, the purpose of it is to allow the person with the benefit to enforce its terms in court. So High Court or County Court. Prima facie remedy is an injunction, but the court can award damages instead. And there's always the possibility of an interim injunction to stop a development in its tracks or in anticipation of a development that's about to go ahead. An injunction is often what people want. That's the practical remedy. And the court has a discretion. The traditional threshold for the question of whether or not an injunction is awarded or damages is that damages, the court has jurisdiction to award damages where what is known as the Shelfer criteria are met. This is not a rule of thumb, but it's a general guide. And that involves 4 things. 1, that the injury to the claimant's right is small. So it's a trivial, if you like, infringement. 2, the value of the injury can be calculated in money. 3, the injury can be adequately compensated for by a small money payment. So there's a bit of an overlap there. And then finally, it would be oppressive to grant an injunction. Now, as I said, that's not a rule of thumb, and a more flexible approach was endorsed by the Supreme Court in the case of Coventry and Lawrence fairly recently. So it's a classic exercise of discretion. That discretion is unfettered. Probably worth noting in this context that in Coventry, Lord Sumption expressly considered the tension between property rights and the public interest in allowing development, and he suggested that an injunction might not be granted in circumstances as a matter of principle where there was a use of land which was being objected to and had received planning permission. But the other members of the Supreme Court didn't endorse that view, and it's worth mentioning that hasn't been the approach of the court since then. So it's a classic exercise of discretion. But if the court does think that damages are appropriate for example, because there's been delay, because that's often the death knell of an injunction if you stand back and wait too long, then the measure of damages is based on negotiating damages, so-called. So that is effectively assumes a negotiation between two parties in the same positions as the actual parties, assumes they would have got together, whereas they didn't in fact do so, but got together and they would have agreed a price for the relinquishment of the covenant without holding either party to ransom. So that is obviously quite complicated. It involves valuation, expert evidence, but that's it. And it's often referable to some percentage of profits from the development that the developer stands to make.
Okay, thanks. So the planning permission doesn't basically prevent an injunction, even though Lord Sumption indicated.
Yeah, it's a factor. I can't say it's not a factor, but it's not. He wanted it to be effectively determinative. But it's a factor. It will be looked at in the round, and what the court is essentially doing is weighing the respective benefits and disbenefits in the balance, looking at all sorts of things. The pot would involve, as I say, delay, the extent of the injury, triviality, the extent of the monetary compensation, conduct, and obviously housing needs and public interest.
Great, thanks.
So Miriam Seitler, then how can you apply, or can you apply to amend or release a restrictive covenant once you've found out that it does burden your land, for example?
This is a popular route to explore because it's well known that you're not necessarily stuck with a restrictive covenant, and there is an avenue that you could pursue to modify it or discharge it. And that avenue is Section 84 of the Law of Property Act 1925, whereby certain people can make an application to the upper tribunal, that's the Lands Chamber, asking for a discharge or a modification of the restrictive covenant. As to who can make that application, so this is often referred to as a Section 84 application because it's made under that provision of the Act. As to who can make the application, it's anybody with an interest in the freehold of the burdened land. As to what does that mean? It's someone that has an interest. Well, that's obviously the freehold owner themselves, but it also could extend to the purchaser of the future purchaser of the freehold land. So someone who already has a contract to buy, but they haven't yet become the freehold owner, and also a holder of an option to purchase. So it's really anyone who can quite clearly show their interest in the freehold land, but in quite a loose sense. You can also apply to discharge or modify leasehold covenants in certain circumstances. So if you're dealing with a covenant in a lease where the term of the lease is more than 40 years and at least 25 years have already expired, so that's certain leases and certain long leases. And the big question that's often asked and on which advice is sought is, what would I need to show in order to persuade the upper tribunal to discharge or modify my covenant? And there's two stages here. There's the jurisdictional stage. So the applicant needs to show one of the grounds is made out, and I'll just touch on the grounds in a moment. And then once you've passed that hurdle, if you've passed that hurdle, then there's the discretionary stage. So the tribunal has a power to discharge or modify, but is not obliged to do so. So you've got to satisfy that second hurdle. So in terms of the four grounds, these are well known. The first one is that by reason of changes in the character of the property or the neighbourhood or other circumstances of the case, which the tribunal may deem material, the restriction ought to be deemed obsolete. The second ground, and this is the one that's most often relied on, the continued existence of the restriction would impede some reasonable user of the land for public or private purposes, or would, unless modified, so impede such user, and the restriction in impeding the user does not secure to persons entitled to the benefit of it any practical benefit of substantial value or advantage to them, or you can rely on this alternative limb of the ground, or the restriction is contrary to the public interest. And in that same ground, you also need to show that money would be an adequate compensation for the loss or disadvantage, if any, which any such person will suffer from the discharge or modification. So that's the second ground, and that's the most popular one and the one most commonly satisfied. Thirdly, the third ground I'm not going to go into in detail, but that's essentially where there's been agreement, either expressly or by implication, by acts or omissions, to the covenant being discharged. That's quite rarely relied upon. And then fourthly, if the applicant can show that the proposed discharge or modification will not injure the persons entitled to the benefit of the restriction. So no injury would be caused at all if we just got rid of this covenant. The other important thing to remember, apart from, so you've got to satisfy one of those grounds, then you've got to satisfy the discretionary stage of the test. So the tribunal will consider many, many factors which go beyond these and decide whether to discharge or modify. And finally, there's the matter of compensation. So if there is a discharge or modification, again, the tribunal has the power to award compensation, and that will be on, there's two alternative bases on which they can award compensation. Either a sum to make up for any loss or disadvantage suffered by the person with the benefit of the covenant, or a sum to make up for any effect which the restriction had at the time when it was imposed in reducing the consideration then received for the land affected by it. So those are two alternative measures of compensation. I think the point to understand here is that what's often referred to as the negotiating basis of damages is not going to be the measure of compensation here. That does have some relevance in the law of covenants, but not to the assessment of compensation under Section 84. So don't be expecting that.
In terms of what you've just gone through, if you've got a planning permission in respect of the burdened land that might appear to be inconsistent with the covenant, how does that feed into getting the covenant released or modified to allow you to implement that permission?
So none of the grounds are, I've got planning permission and therefore the covenant should be discharged or modified. That isn't one of the grounds, and the existence of planning permission in itself will not lead to your application being successful. However, it's not completely irrelevant. On that second ground that I said was the most popular one of the conditions to be shown is that the development proposal that you want to do or that you have already gone ahead with is a reasonable user of land. And if you have planning permission, then it almost automatically follows from the fact that you have planning permission that this is a reasonable user of land, which is impeded by the covenant. So it's significant in ticking that box. But as I said, the fact that you have planning permission does not mean in itself that you satisfy that public interest ground, which I mentioned, nor does it mean that you can show that, that your proposal or that the covenant doesn't secure any practical benefits of substantial value or advantage. So it's not an automatic, it doesn't enable you to automatically tick any of those boxes. The other point to mention is that there is a specific provision in Section 84 which requires the tribunal to take into account certain planning elements. So this is subsection 1b, and it tells the tribunal to take into account the development plan and any declared or ascertainable pattern for the grant or refusal of planning permissions in the relevant areas. So that's sort of the planning background rather than perhaps the planning situation for this specific property. And it also tells the tribunal to take into account the period at which and context in which the restriction was created or imposed and any other material circumstances. So that is really urging the tribunal to take into account the widest range of factors, certainly at the discretionary stage. And it is the case that at that stage, the tribunal will take into account the existence of planning permission. So again, relevant but not determinative.
Thanks very much.
Great, thanks. Just one very quick last one on covenants, Miriam, other Miriam. If you've already in breach, you've already built your building or changed your use, can you discharge the covenant retrospectively?
Okay, short answer, yes. In principle, there's no time limit for a Section 84 application, but conduct, remember the discretionary, there's a second stage, discretionary, so conduct might come in at that point, but we'll deal with this in the scenarios in a bit.
Okay, great. So we'll move on then very quickly just to a few questions on easements if we can. Kim, do you want to start on the easements topic?
Yep, so as we started on covenants, Miriam, Seitler, can you just explain very briefly what is an easement and what kind of rights can be the subject of an easement?
Yeah, so an easement is a right over the land of another person. The reason why it's so significant is that it's a proprietary right rather than just a license to go over someone's land or do something on someone else's land. It's proprietary, which means that it has the potential to bind successors in title, unlike a license. Also significantly, it can't exist on its own. So it has to accommodate or be pertinent to benefit benefited land. In that sense, it's similar to a covenant. There has to be a benefited land and a sort of burdened land. And there's two types of easements: positive easements, so that would include your right of way, or negative easement, so that's like a right of light or right of support.
And okay, following on from that then, other Miriam, how do they come into existence? How do they come about, easements?
That's a simple question. Unfortunately, there's not one simple answer. They can be created in a variety of ways. So, I mean, the shopping list for that is express grant or express reservation in a deed, first and foremost. If they haven't been expressly granted, they may be implied under Section 62 of the Law of Property Act, where there has been a sale of part. That section deals with rights that are known or reputed to be enjoyed at the time of the grant. So it's effectively a conveyancing device where the statute implies into the conveyance the words that are assumed to have been intended to be there. So that's Section 62 one needs to watch out for. If that box isn't ticked, then they can also be applied under other statutes, such as usually utilities. So the passage of water, sewerage, electricity, other services can be passed under specific statutes. There's categories of implied grant. So, for example, if you transfer land which is then landlocked and you haven't expressly granted a right of way, then the court will imply by necessity a right of way in that scenario. And then you can also acquire rights by prescription, so through long use. And those rights don't need to be registered, so they can be a bit of a danger zone so far as developers are concerned. And then finally, proprietary estoppel and equity. Equity might step in and help someone by finding that there is an easement in circumstances where there's been a representation made to someone that they've got the rights, and someone that's stood by and allowed them to assume that to their detriment. So equitable easements can also be to come into play here. So a whole range of various circumstances in which they can be created.
And turning that question around, Miriam, how can you lose or terminate an easement? Is there a way of doing that, or is it forever and ever binding on?
So they can be terminated in a number of ways. Firstly, by express release. That would be by deed if it's to take effect at law, and you would also need to take the consequent step of removing the entry from the land register. There's also implied release, so this is a second method of possible release, and there's a lot of discussion and I think confusion about whether easements can be released impliedly by abandonment. The position is that generally the fact that an easement has not been used for a very long time does not in itself mean that it's been abandoned and therefore released. The test for implied release, the threshold is actually quite high, and you're only going to be successful in showing that an easement has been abandoned and impliedly released if the owner of the dominant land does some act that clearly indicates a firm intention that neither the owner nor its successors will make use of the easement in the future. So just not using it for a certain number of years, it may not suffice. The threshold is quite high there, and it's quite difficult to show abandonment. And then finally, operation of law, an easement can be terminated in this way. So that's, for example, by unity of possession and ownership of the freehold estate of both the dominant and the servient land. So if the freehold ownership comes into the hands of the same person, then the easement will be extinguished.
Okay, just last one on easements. Miriam, Stacey, can they be overridden? Can you explain a bit about that?
Yeah, well, the first thing to say, by overridden, there's no statutory procedure equivalent to Section 84 for easements. That's a common misconception. So you can't override in the sense of extinguishing or modifying. And if they haven't been abandoned, as Miriam just went through, then the circumstances in which they can be overridden are fairly limited. They can be overridden by the operation of Section 203 of the Housing and Planning Act 2016, which repealed the old Section 237. But 4 conditions must be met in order for Section 203 to be engaged. So those conditions are that the land has become vested in or acquired by a specified authority on or after the 13th of July 2016, or appropriated by a local authority for planning purposes. And what is a specified authority has a specific statutory definition. So that's the first condition. Secondly, there must be planning consent for the building or maintenance work or use. Thirdly, the specified authority could acquire the land compulsorily for the purposes of the building or maintenance. And fourthly, the building or maintenance or use is for purposes related to the purposes for which the land was vested in or acquired by the specified authority. So one needs to look at those conditions very carefully, but in a nutshell, section 203 is a useful tool for developers to avail themselves of, and that is a mechanism by which an easement can be overridden, but it's the only one.
Great, thanks very much. Well, we're getting a little bit pressed for time, so I think we should move on to a bit more detailed discussion of some particular scenarios. So we've got a few coming up on the slides. So the first one, scenario A, we've got a cancer charity, a notional cancer charity who owns a hospice and surrounding gardens, and that land benefits from some restrictive covenants preventing development of next door land. But then we have a developer who obtains planning permission despite that covenant and goes ahead with development, which includes housing and affordable housing. And the charity refuses to release the covenant. There's then obviously a conflict between the covenant and the development, which has planning permission. We're just going to ask a question on the poll, see what viewers think about this. And just so you know, everyone, you can move your poll around the screen if you want to have it there while you're looking at the scenario. And we'll see what Miriam thinks about this before we reveal what everyone else has thought. So Miriam, what are the things that a developer needs to be aware of in that sort of situation?
I'm intrigued by the polling. It's going up and down. Okay, I'm going to end it shortly, but before I do that, in terms of the ground that the developer in this scenario would rely on, it's the one that Miriam referenced earlier as being the most popular or the most usually employed. So AA, which is the ground by which the tribunal can discharge if it's satisfied that the covenant impedes a reasonable use of the land. And as she said, and that includes that the covenant is contrary to the public interest. So in this scenario, what the developer would look to rely on is the fact, I'm going to end the polling now, is the fact that the public interest is the critical need for affordable housing. And that might be thought, the developer might hope, would trump the private rights. So that's what the developer would do. But the problem is, as again Miriam suggested, there's a second limb to this. It's not simply the jurisdictional ground, it's also the discretionary ground. There are two stages to this. And the developer shouldn't assume that the tribunal would inevitably allow the development underground AA on the basis of public interest, because conduct is also critical. And in this scenario, third bullet point, the fact that the planning, the fact that the developer's gone ahead in the knowledge that there is a covenant, that they would be in breach and the development was being objected to, well, that's a problem. And that very issue arose in the recent case of Alexander Devine Children's Cancer Trust, which went all the way from the upper tribunal to the Supreme Court. And in the upper tribunal, the tribunal found for the developer. So the developer succeeded. I'm going to share the results now, so we see where we are. Okay, so most people said no. Well, the yeses were right at the upper tribunal stage, but were found not to be right at the Supreme Court stage. And the reason for that is the Supreme Court emphasised this two-stage approach. So at the jurisdictional stage, i.e. can you make out the ground, public interest, you have to ask simply a very narrow question, which is the impediment, i.e. the continuation of the covenant, contrary to the public interest? And the answer to that is, well, yes, because affordable housing is important. So that's relatively easy for the developer to satisfy. But the second stage is whether the upper tribunal should exercise its discretion. And that's where the developer fell down. So the Supreme Court said that the fact that the developer proceeded in cynical breach, they created a land conflict by their conduct. And they are relying on that land conflict in asking the tribunal then to modify retrospectively, going back to your question to me earlier, Jenny, can you? Yes, in principle, but it will be looked at askance by the upper tribunal, by any court, frankly, where you're relying on the very breach that you've created. Now, the Supreme Court held back from saying that all cynical breaches would be automatically the death knell to a modification application. They didn't go that far because that would be too rigid, because there is an unfettered discretion, but the courts will be very reluctant to allow developers to profit from their own breach. So the lesson to be drawn from here is that, you know, the developer is unlikely to succeed. So Good. The poll is, most of the pollsters are right. Couple of practical pointers for developers to be drawn. Obviously, try and agree terms with the charity. That's the first point. But if you can't do that, it's worth considering whether the plans for the site can be laid out in a way that would sidestep any breach. So in Devine, they could have built on an adjoining plot which wasn't subject to the covenants. You can, for example, put car parking on the bit that housing is on without breaching. So see whether you can reformulate or reconfigure your plans. And then finally, make sure the application is made, certainly before you start to build, but ideally, possibly before the planning permission application is even brought.
Although just on that last point, presumably having the planning permission would help you in your public interest argument. So would you think that the outcome would have been different if the developer had applied to get rid of the covenant when he got planning permission, but before he started building?
Well, if you've got planning permission, then, well, if you've got the covenant modified, I suppose it helps to say that you're going to be able to get planning permission. You don't necessarily need the planning permission in your hand. You can get a pre-app, for example. Yeah. You can get an expert to say that there would be no impediment to planning, and, you know, give an expert report as to the likelihood of planning being granted.
Just waive your affordable housing promise as the public interest, exactly. I suppose, rather than necessarily having the permission. Yeah, okay.
And this is the specific scheme. I think that's what you need to do, not for anything. It'd have to be for a specific scheme, which is in the public interest. Yeah.
Sure. Okay, thank you. So we're going to scenario B then.
I've got to get rid of this poll. Let me do that now. There you
go. So moving on then to one about, right, we're looking at rights to light now. So Miriam, Seitler. So you've got here we've got an old office block in the City of London, and then someone who owns neighbouring development site and has permission for a new residential block of student accommodation on that land. So the owner of the office block their surveyors have advised that the top 2 floors of a new development will infringe the light enjoyed by the office block for over 20 years. The planning decision expressly states that the development would not be objectionable on the ground of infringement of light because 8A's building has been and continues to be used for commercial rather than residential purposes. The owner of the office block did not object to the planning permission, and the owner of a neighbouring land has commenced the works for the development. So let's have a quick poll again. What does the audience think? Is the owner of the office block likely to succeed in getting a mandatory injunction? And then let's give people a few moments to cast their votes, and then I'll get Miriam's thoughts on it.
Just to be clear, that's a mandatory injunction to remove or stop building the. Yeah, I mean it's a mandatory injunction to remove parts of the building that infringe the rights of light.
Exactly. All right. Shall we stop the poll? I think everyone's had a few.
Or just leave, yeah. You can leave it going, and then people will be better informed and they'll vote better once they've heard what's said. I think that the key to this scenario is understanding how the planning test for sort of infringement of light or assessment of daylight and sunlight, I don't know how the planners do it, interacts with the rights of light in private property law, and to what extent will one influence the other. From the property angle, the test of whether a right of light has been infringed rests on the assumption that if you have a right of light, then what you are entitled to is the uninterrupted access through your ancient windows of a quantity of light, the measure of which is what is required for the ordinary purposes of inhabitancy or business, according to the ordinary notions of mankind. So the focus is on whether the remaining light in the room is sufficient according to the ordinary notions of mankind, which is obviously quite a difficult test to apply. But crucially, that is not the same test which is applied during the planning process when any sort of assessment of light is made. So when applying this test in the private property law context, there's no consideration given to the existence of artificial light. So the fact that in an office you would have the lights on all the time is completely ignored. And also no consideration is given to reflected light. Not only that, but there's also consideration given to not just the current use of the property. So although it's currently used as an office, there's also consideration given to possible, reasonably plausible future uses of that property. So if there is a likelihood, or at least a reasonable possibility, that that office block would be used for residential purposes, then that will also be included in the test that the court applies. So without going into too much detail on this, the way that surveyors and the courts assess this question of interference with rights to light is by using something called the Waldron method, which I'm not going to explain because it's quite technical, but it's been in long use for 100 years, and that continues to be the method by which the court will assess the question of whether there's been an infringement of light. So the short answer really, and I'm just going to end the poll now, it's quite tight. Has that been shared? Yeah. So the short point is that the Waldron methodology will not take into account the planning authority's own assessment of the impact of light. These things are kept quite separate. So it's not a defence to the claim to say that the planning inspector or the planning authority, they thought there was no problem with light. If once you get to the court makes an assessment that there is an infringement with your right to light. Then there's also the question, so that's the difference between the rights to light tests. Then there's this question about remedy because the building has gone ahead. So the first question to think about is, would you get an interim injunction? There's obvious burdens for an applicant in seeking an interim injunction because they'd have to give an undertaking. So an undertaking in damages. So that might be an unattractive prospect. It's also possible that if you don't apply for an interim injunction, then your failure to do so will be used against you when it comes to seeking a final injunction. So the bottom line on interim injunctions is that although it's not a prerequisite to seeking a final injunction, it is perhaps a small factor that will weigh against you when you're seeking a final injunction. And then this big question that we've polled on of what's the likelihood of the final injunction being obtained, given that the developers just pushed ahead despite the objections from the neighbour. Again, the court will weigh up the public interest in not pulling down the development, so that will be a consideration. The building's already gone up and it would be a waste of resources and time for it to be pulled down again. But also the court's very aware of sending a clear message to developers that you can't just bulldoze through somebody else's property rights, and they are very discouraging of that. It's not unheard of, even in quite recent cases, for the court to order mandatory injunctions requiring buildings to be built down, to be pulled down, or parts of buildings to be removed. And that's because the conduct factor weighs so heavily with the court at the injunction damages stage. And if a developer has behaved badly in this way, then it will certainly count against them.
Is it fair to say that it might depend on, I mean, we don't have all the facts here, but of how far the developer has gotten in terms of building out the development?
I think that would be a factor, because that does weigh in the public interest slightly, but it also, the fact that they've proceeded for longer despite a longer period of objection is also going to weigh against them. So it's really a balancing act. So I think generally the advice would be that there is a very significant risk that that a mandatory injunction would be obtained.
Okay, so
Can I just jump in there and just say very, very similar facts to this scenario. If anybody wants to kind of read a judgment, is that interested, in the case of Beaumont and Florala, there wasn't an injunction ordered, to the surprise of possibly practitioners and developers. So that was quite a punchy decision. And it is an example, as Miriam said, of a case where there has been an order granted, a mandatory injunction granted, which perhaps wouldn't have been what people would have expected.
Right, I think we need to go on to scenario C. We're coming to the end of our time, but I'm hoping we're going to run over a little bit, and we're going to keep going because we've got 2 more scenarios to discuss. So I hope you can stay around. But as I said, there will be a recording available afterwards anyway, if anyone needs to leave. So we'll move on to our 3rd scenario. And this is a situation where a developer owns a car wash and an adjoining lane, which actually runs across the back of a row of terraced houses. And he has the benefit of planning permission to develop the land, which involves building over that lane, and has started work. Meanwhile, one of the owner of the terraced houses has come forward claiming that part of the development encroaches onto his garden, and he has a right of way over the access. And in claiming that, he relies on a 1970s transfer of his house, which included the grant of rights of way, if any, over the lane. And in the alternative, he relies on an easement acquired by prescription. but he never objected to the grant of planning permission. And there's also an old shed across the back of his back garden, which would have made access to the lane from the house impossible. So against all of those facts, you've got the developer who has started work in the absence of any objection from Mr. B. So let's just see if we can put our poll question up. So as I said, the developer's faced with these claims after planning permission has been granted. Can he safely proceed with the development regardless of B's claims? So the polling is going on a bit. Let's see what Miriam says about what would be taken into account in those circumstances.
Yeah, well, this is a developer's nightmare, isn't it? Because they're getting on with it, and then suddenly somebody pops out the woodwork. We're assuming because the lane's going to be built over, there would be an actionable interference. First thing to say is that failure to object has no bearing whatsoever on property law rights. So the developer needs to form a view about whether there's a real risk that this is an easement that's been acquired that is capable of being enforced, or whether this is a try-on, and then how best, and the dispute regarding the boundary and how best to resolve it. Unpacking it a bit, so there are a couple of issues. Firstly, the express grant that's being relied on, 1970s conveyance of his house. So there's a capacity point whereby the owner of his house wasn't the owner of the lane, potentially, and you can't grant something rights over something that you don't yourself own. So if any is the clue there, did the owner of the house to whom his house was sold, by whom his house was sold, have the capacity to grant an easement? And if he didn't, then you could take a view about that. Do some detective work and find out who owned the lane originally, whether it was the same party. The second potential knockout blow to an express easement is what were the registration requirements and whether they were complied with, because if the lane was registered and the easement hasn't been protected by registration, the absence of that protection might be fatal to the enforceability of the easements. But that isn't the complete answer, because there's also prescriptive rights being relied on, and registration requirements don't apply to prescriptive rights. So there's no need for an easement acquired by prescription to be completed by registration in order for that easement to take effect at law. So again, detective work. Prescription, you need to have 20 years of use as of right, so without force, without secrecy, and without permission. You could, I guess, take a view as to whether anyone's seen anyone using it. But I think the best point for the developer is the shed, because if there's a structure at the back which has made it physically impossible, find out when it was put up. Goes back to Miriam's abandonment points. Now, non-use isn't enough, but if there can be objectively ascertained an intention by the owner of the house not to use any right at any point in the future, so a permanent structure has been erected, then that might have led to the easement being abandoned, if indeed it had been acquired in the first place. All of that's really interesting, but what it doesn't do is remove any risk for the developer. And there are two real options here. Oh, sorry, before I go on to that, the boundary points. I should say the boundary point is a difficult one, because the owner of the house is saying, well, you're encroaching on my boundary. If they're pointing to the plan on the land registry, but that's not enough, because there's a general boundaries rule. So the red line on the plan is not determinative. And if there's a true boundary dispute, then the only way of resolving that would be to get advice from a boundary surveyor and then go to the land registry for a determination of the boundary. So what are the options for the developer? Can it proceed safely? Well, no, I think I agree with that. I mean, it's an option, I suppose, for it to proceed tentatively in order to try and flush out the householder and see, but the risk with that is that the developer might get slapped with an injunction application, and then have to kind of unwind fairly quickly, and that would be costly if you've got contractors lined up, less than ideal. The alternative, it's not particularly attractive either, would be to go off and seek a declaration that the easement hasn't been acquired or was abandoned and get a boundary determination, but that is going to cause delay and be costly. So which is why I introduced this by saying this is a developer's nightmare. Yeah. But I agree with the results.
Bit of a minefield, basically.
Yeah.
No safe way forward, no good options, really. Okay. All right, thanks for that. So should we move on to D then, I think, Kim?
Yeah, sure. So one final one then. So here we've got a local authority has granted planning permission for residential development. Same local authority is also the beneficiary of a restrictive covenant that restricts the use of land to industrial use only. So the planning permission, if implemented, would be in breach of that covenant. The developer makes an application under Section 84 for discharge, modification of the covenant on the basis that it impedes a reasonable user of land. Can the local authority resist the application despite having granted permission for that scheme and being the beneficiary of the covenant? How strong are its prospects of doing so? And what about if at the time that planning permission was granted there was need for housing, but by the time the covenant issue is in dispute, there's no longer the same need for housing? So poll question for the audience: is the developer's application for discharge / modification likely to succeed? Yes or no? What do we think? And that poll should be coming up now. There we go. And Miriam, I don't know if you want to get us started on some thoughts on this.
Yeah, this scenario is all about the extent to which a local authority can pretend to be two different parties and really wear their two different hats completely separately, and say we do one thing when it comes to planning applications and we act as the local planning authority, but we also own private land and we have private property rights and we're entitled to act completely separately in that regard, which I think is a situation that arises more often than you might think. The difficulty for the council here is that obviously they've given permission through the planning system, and then a few years later they're seeking to object as a property owner on the basis of their private property rights. And they obviously hold a unique role in this sense. So the key question is, are they able to separate those two roles? There's quite a lot of case law on this, and the most recent case, which is not that recent at all, but suggests that there is an inconsistency in the council's position if they do try to grant planning permission through the planning system and then make a case objecting to modification or discharge in their trying to wear their other hat. And that's because, just as a matter of fact, they've obviously accepted a number of propositions about the acceptability of the proposed development. And so when they then try to argue in the tribunal that the covenant in fact secures for them many practical benefits of substantial value or advantage, it's actually quite difficult for them to do that on the facts, because they've simultaneously said that actually the proposal is completely acceptable. I think the best point in this scenario is probably the change of facts over time. So they could, and this was exactly what occurred in the case that I'm talking about, that if they can say where the planning permission was still valid, but many years had passed. And so they said, well, we granted permission 3 years ago when there was a need for housing. Now there isn't that same need for housing, and therefore the factual situation has changed. But again, they obviously have to make out over sometimes quite a short period the life of the planning permission that the facts have changed. And on the fact of the particular case that this scenario is based on, they weren't able to show that the circumstances had so changed, and therefore they were stuck with the position that they had taken on the planning permission, and they weren't able to successfully resist the discharge modification application. So just to end the poll, is the developer's application for discharge likely to succeed? Most people said that it was, and I would agree with that, because as I said, I think the council does have some difficulties given the position they previously took.
Yeah, that's quite interesting, Miriam, because obviously the you quite often, well, it's certainly not rare for a planning authority to make in its ownership of private hat, so as an owner of land, to make an application for planning permission to itself. And so in those circumstances, because that's allowed to happen, it very much relies on the fact that a local planning authority can wear two hats, and that there's not a conflict in that situation. And yet, your answer there does tend to elide the two a little more, that the courts would look at the local authority's actions in its wearing its other hat and hold that against it effectively. That's quite interesting. Yeah.
And also interesting in the context of housing land supply, if a council feels like its hands are slightly more tied in the planning application because there's very different factors that it has to take into account versus what a tribunal might take into account on the Section 84 application. So it doesn't seem like it's clear. It'll just depend on the facts of a particular case.
Yeah.
Great.
Well, thanks to everyone for that. We are quite well over time, but we have and we have had some questions which are really it's just really good, and we will definitely feed those into a future webinar in this series. And we hope to do many more in this series because they do seem to be quite popular. And to that end, we have got a final poll to come up to help us, hope that has come up. I've just minimized it and it's gone, but anyway, to help us decide on future topics. So if you could all vote in that webinar as to your preference for future webinars in this series, that would be really helpful. It is on the screen, is it, for everyone? I've lost, yeah, good. Mine's gone, but I think that's my fault, just my screen. So if we can do that, I can't control it, so I don't know whether we are, have we got it there? Still there, okay. But as I said, thanks everyone very much for coming today. I hope it's been useful. There does seem to, as I said, there does seem to be some enduring interest in these crossover talks. So we are hoping to hold some more in the future and to incorporate some of the questions that have been put forward. But unless there's anything further, I think we'll conclude that for today and look out for some more tweets and LinkedIn messages about future webinars. Thanks very much, everyone.